Welcome to Getting Real. I'm Dan DeSciullo, and today I'm sitting down with Steven Yadegari, founder and CEO of FiSolve. Steve has a rare blend of experience that puts him in his own league, spending more than 25 years navigating the highest levels of financial regulation, from senior roles at the SEC to 16 years as COO, General Counsel, and Chief Compliance Officer of a leading money management firm. He's advised everyone from hedge funds to private equity firms. He currently serves on multiple boards, including an Irish UCITS fund. But what makes Steve's perspective truly unique is his dual experience. He's not just a regulatory expert, he's also a master negotiator and mediator with 25 years as an adjunct professor at the Law of Cardozo, a former president of the State Association for Conflict Resolution, and a federal mediator. He's trained SEC enforcement staff, contributes to the SEC's Asset Management Subcommittee, and is a sought-after speaker who knows how to resolve the most complex issues in financial services. Steve, thanks for being here.
Really a pleasure, Dan, and thank you for that wonderful introduction. I hope to record it and share with other people. I'm really flattered, so I appreciate it.
So Steve, let me ask you, what originally drew you into law and finance? Were you always fascinated by the markets, or did you just stumble into this?
Yeah, fair question. I suppose growing up, I actually probably had more of an interest in sciences and envisioned maybe going to medical school one day. And, a funny thing happened on the way across that path. I came across sciences and advanced math classes in the university and just found that it really wasn't for me. My brain isn't wired that way, unfortunately. But instead, I found that, I did seem to have an aptitude for writing, for psychology and thinking through issues. Problem solving was something that really always excited me. And so that kind of led me down the path more towards law. And ultimately, I ended up going to law school.
Well, you've worn lots of hats. SEC, COO, professor, mediator. What role has shaped you the most as a leader?
Oh, wow. It's a really great question. I think when I was in law school, I had a unique opportunity. I was a student at the Benjamin N. Cardozo School of Law, which happens to be where I'm now an adjunct professor. And at the time, and it's still offered today, I participated in a mediation clinic, which really taught a different type of negotiation, which probably doesn't get enough attention and frankly isn't applied enough in our society, which is, of course, principled negotiation. And the art of principled negotiation requires a lot of techniques that I think can be very helpful to anyone in a leadership role, including the ability to really actively listen to the person with whom you're speaking, maybe relay information back to them in a way in which it's not going to be as inflammatory or positional. And most importantly, it really encourages just trying to think outside the box when it comes to solving problems. It is a proponent of inventiveness and creativeness when it comes to problem solving. And I find that it also lends itself to just being more open when you're speaking with people, and that transmits authenticity in communications. And when you're meeting with people and they feel as though you are authentic and you're essentially real. I mean, we're here in the Getting Real podcast. That really resonates with people. And I think as a leader, there's no single trait that's more important than authenticity, that you have the trust of the people that you're working with and they can believe in you. And when you say something, they know that they can count on it.
Wow, great answer. Tell me a story from your early career that still makes you laugh or cringe.
I have a great one. So I was leaving the SEC. I'd worked there for my entire young career, 4 years, and I went to a law firm called Proskauer. It's called Proskauer Rose back then. A white shoe firm working with the most prestigious financial services firms. The lawyers there were all the top of their game. And I worked for one partner, may rest in peace. His name was Saul Cohen. Saul became a real mentor to me. And he really taught me how to transition from working for the government and thinking about the way in which policy is made, how enforcement recommendations are considered, and instead act as an advocate for our clients. And so one of my very first assignments, Saul called me in and he asked me to write something that we were going to use to respond to the government who had made some allegations against one of our clients. And I wrote it And, I was really proud of it. I spent a lot of time on it. It was my first project for them. I gave it to Saul. Saul read it, called me into his office. He sat me down. He said, look, like this is really well written. I know you're going to do great things here. You're going to be a wonderful lawyer, but I'd like to take a different approach here. And I sat there, with my notebook and like ready to like receive the feedback. And he said, I want the regulator to read this and feel as though we just kicked them in the balls. So why don't you go back and try writing it again that way and then come back to me? And, the real lesson there was I wasn't there to kind of help make the government's case. I wasn't there to make it easier for them, but really I was there to be a zealous advocate for my client and make sure that in a proper way, I can push back. So I maybe didn't go as far as like making them like, react the way Saul wanted, but at least I knew that I really had to do a better job to be a more effective advocate. And that's something I really carried with me for my career from that point forward.
Oh, that's great. Was there a light bulb moment along the way when you realized that you wanted to start your own firm?
I think so. So I'm in my early 50s now, and I was probably a little bit later than maybe some would start a company or take that entrepreneurial leap. I come from a family of entrepreneurs. My father, my uncles, a lot of my role models. It's something that I've always kind of had as a burning desire throughout my career, but I'd always been in really great positions. I was very fortunate, worked for the SEC, a prestigious agency, in a very, in a terrific role with fantastic people, worked for prominent law firms. Krim Rosenthal McGlenn is a preeminent, wonderful money management firm that continues today, 50 plus years in business. And so I always had these great roles with positions of responsibility where I was making an impact, and I really enjoyed it. But in my last few years at my prior firm, I just felt as though I wanted to do something different. I wanted to take that leap and try. I knew I was getting to the point in my life where it's like now or never. You take that leap or, you're going to lose that opportunity. That window's going to close. So for me, that happened about 5 years ago. And a lot of the ideas, the concept for FiSolve, our company, really kind of came to light for me. And I just made a decision. There was a certain point in and this was during COVID, mind you, early 2021. I knew that that's what I wanted to do. I'd say by June of 2021, I had the concept, I had developed a logo, I had developed a business plan, and by December, it became real.
So tell me about that journey. What's it been like for you over the last few years, going from sort of not an entrepreneur with all this experience, but then diving into the entrepreneurial side?
It's been a really very, very rewarding. A lot of hard work. I'm working as hard as I ever had in my career, probably harder. People will say when you're doing it for yourself, it doesn't feel as much like work, and there's probably some truth to it. But I think some of the things I really appreciate, and I feel very blessed and fortunate that the concept has been validated and we've been successful and we're growing what seems to be a successful business almost 4 years into it. Some of the things I would attribute to that success, aside from just the hard work, which is a prerequisite, is throughout my career, I've always managed and really put time into caring for the relationships that I developed. With my professional colleagues, with service providers, going back to that idea of being authentic, I was always fair with them. They always knew where they stood with me, tried to treat people the right way, even if they were doing work for us. And it's now paying dividends because a lot of those same people who were essentially working for me when I was in a position of making decisions as to whether or not we wanted to do business with them on behalf of my prior firm, they are now becoming some of the best sources for me when it comes to generating new business by way of like referring clients to us, spreading information about what we're doing in the industry to others, generally just being supportive, serving as a sounding board or a resource. And I wouldn't be enjoying the level of success I have thus far without their support.
Wow, that's awesome. From one entrepreneur to another, I just think it's awesome to take the leap of faith and be able to be successful years later. So there's a lot that goes into that. So hats off to you.
Yeah, thank you.
Let me
And
get into some more technical sort of questions. You've trained staff in the SEC's Division of Enforcement. You present at their Chief Compliance Officer outreach programs from your inside view, what do most firms misunderstand about how the SEC actually thinks and operates?
I think there's always a lot of apprehension when it comes to dealing with your regulator, whether it's the SEC, it's FINRA, it's the CFTC, NFA, if you're in Europe, the FCA or Central Bank of Ireland. Like, people are always nervous, and rightfully so, when it comes to your regulator. A misstep with a regulator can have obviously massive ramifications for the business and can put you in a lot of trouble, could potentially take you out of business altogether. So I understand where the concern and apprehension comes from. In my experience, if people are putting in the time and resources to develop their programs properly, if they spend the resources on having a strong compliance program, I like to call it being in a ready state, so that if you are examined, if you are visited by a regulator, you can show them the good works you're doing. Well, it's not going to be a fun process. It takes time, and regulators come in appropriately with a certain amount of skepticism when they begin a review. If you can demonstrate that you're doing good work, that you are adhering to your obligations to your clients, that you're meeting your standard of care, and you can show that to them, there's no reason why that experience cannot be a positive one. And the outcome could be something that can really just help you push the program forward in a very positive way. And in many of the instances, for the company that I work with for 16 years, in my time there, I think we were examined 3 times. Each of those examinations, like, while they took time, and it took a lot of attention while they were with us, at the end of the process, we felt really good about what we were doing with our program. The staff, informally gave us credit for a lot of the things we were doing, even when there were some maybe areas where we could have done a little bit better, because we treated them with respect and we were open with them, and they could see the genuine effort we were making to do the right thing. I think we got some kind of like credit for that, and it led to a much better outcome than the mistake I think sometimes firms make, is they're very guarded when it comes to interactions with their regulator, and maybe not as open as they could be. And look, there's a fine line there. You have to be really thoughtful about how you interact with your regulator. But overall, if you're putting in the time and effort before they come to you, and you can demonstrate that when they're with you, there's no reason why it can't be a very constructive experience. And that's really what most of these examiners and regulators want when they interact with the firms that they have oversight. They want to see that you're doing the right thing, that you have the right program in place. And if they don't, they'll hold you accountable. The biggest mistake you could do or make is being dishonest, or trying to fabricate, and like any of those types of things will just get you into so much trouble. And I've seen that happen at some firms. It's really unfortunate. It's really important for firms to put in the time and effort, so that when a regulator, or frankly an important client, comes and does a review, you have all the right things in place.
Okay, so outside of being guarded or dishonest, when you're sitting across from SEC examiners or enforcement staff, what's one thing that separates firms that navigate it smoothly from those that make it worse for themselves?
Well, I'll tell you, in the last 20 plus years, the SEC has become much better at telegraphing what's important to them. For example, they will publish their list of enforcement and examination priorities every year. It's almost like you get their playbook. It's like, hey, industry, these are the things that matter to us. And they'll give you examples of the enforcement cases they brought over the course of the last year. They'll give you information about the areas that they're concerned about currently, which means those are the things that they will ask you about if you are examined in the coming months. And so all you have to do is pay attention to those publications. The chairman of the SEC gave a really important speech a couple of days ago, lead the enforcement efforts under his chairmanship. And so, like, paying attention to those types of things will give you some insight as to how the regulator is thinking and what is important to the regulator. So there shouldn't really be any surprises if you're examined, if you're visited, and if you do find yourself in a sticky situation. There's also some guidance as to like how you might navigate through that. And it puts you in a position to understand when you should be reaching out for some outside assistance.
Great. Here's another technical question for you. You contribute to the SEC's Asset Management Subcommittee for Small Advisors and Funds. What are the unique challenges that smaller firms face in this regulatory environment that big players don't have to worry about as much?
Cost of doing business. That's the hardest thing for smaller advisors. And it's one of the reasons, honestly, we started FiSolve. Like if you look at the back of my business card, it says leveling the playing field. And what I mean by that is, Dahlia Blass was the SEC's division director of investment management, I don't know, something like 5, 7, 10 years ago. And she made the observation back then, which was like just so on point, which is the industry needs and benefits from smaller advisors and smaller managers and smaller firms because they bring a level of ingenuity and innovation that you may not find at some of the bigger players. And if it becomes cost prohibitive for some of these firms to remain in business because of either operational costs, compliance costs, regulatory costs, operational costs, what ends up happening to them? One of two things. One, they go out of business because they just can't afford to keep the lights on. Or two, they get acquired and rolled up into a much bigger organization. And then, that benefit, the ingenuity, the innovation it gets diluted, if not entirely lost. And so the toughest challenge, I think, for these smaller firms is to first, the regulators can be helpful in making distinctions between larger firms and smaller firms. And to their credit, they're doing that. There's a new rule that goes into effect for larger advisors in December around Regulation SP, which is a privacy provision. And the SEC said, for larger advisors, we expect you to be in compliance by December of 2025. But for the smaller advisors, they said, we're going to give you more time because we understand it. You may not have the same level of resources to get everything in place as quickly. So for you, we're going to give you till June of 2026. Like that type of distinction is extremely helpful and valuable. And there are other places where there might be reporting requirements that are different for a large manager as compared to a small manager. And that helps. It helps anything that eases the burden and can help with cost. That's how you can help support these smaller boutique firms that are vital to the investment community and bring such value to the individual investors that are out there who really benefit from their presence in the marketplace.
Great answer. Okay. Back to some more playful questions. What's one rule or regulation that most people misunderstand, and what's the reality?
Well, there's so many. And I don't want to get too technical. Something that jumps out for me right away is if you're an investment manager and you happen to be a manager that has shorting as part of your strategy, there's a technical rule that would prohibit you from going out and purchasing shares in a secondary offering for purposes of covering a short position. That's just like a per se technical violation of a rule, and it's like a very strict liability situation. So, every year or two the SC will bring like 7 or 8 cases at one time where they remind the industry you can't do this because it could be deemed to be a manipulative practice. So that trips people up. One thing I will say generally about regulation, I think this is good news. The Gensler administration, former SEC chairman, and his enforcement prerogatives or priorities, some would describe as there was a lot of regulation being done by enforcement. And what I mean by that is, as an example, there were cases brought that totaled in the billions of dollars in fines for financial services firms, including investment advisors and broker dealers, not retaining text messages and other forms of electronic communications, WhatsApp and other things. One way to have communicated a concern about that practice would have been to issue a risk alert or an advisory, or had conversations with the industry groups. And there's a number of really wonderful ones in our industry. We're really blessed with great advocates in these advocacy groups, and said, look, we're worried about this and we're going to start looking at it carefully. And we're just putting everyone on notice that beginning next year, we're going to start bringing enforcement actions. Instead, what happened was they started bringing enforcement actions that really just popped and made headlines, and everybody all of a sudden started to scramble and say like, oh my gosh, like look at these fines, like we got to do something about this. And when they were done, they brought actions against hundreds of investment advisors and broker dealers and brought billions of dollars in fines and penalties. And everybody's now come in line, and almost every firm I know has found a solution to this issue. But, why handle it that way? And the other thing about the Gensler administration is they passed or at least proposed and adopted a number of rules that were very like prescriptive in nature for investment advisors. Investment advisors are subject to a fiduciary duty. It's very simple. Just do what's in the best interest of your client. You don't need a prescriptive rule to know what is in the best interest of your client. And what's in the best interest of a client for one advisor, the action might be different for a different advisor, just depending upon the type of business they're running. And so the Advisors Act is very principles based, and it's embedded in that fiduciary duty. And so the Gensler administration didn't like that and tried to kind of force feed firms specific requirements that didn't always work with their business models. And consequently, and also they did it with very short comment periods. They ran afoul of these requirements to do cost benefit analyses. It really felt like, to many of us, like it was just force feeding of regulation. And so, not surprisingly, a lot of these rules have been overturned. They've been withdrawn, and it's just a colossal waste of time, frankly. Under the Atkins administration, we're seeing that they're clearly moving back to this fiduciary based approach to advisory regulation. Frankly, it's a breath of fresh air. It's very good for everyone. And it's really the way things ought to be done. Most advisors are well-intentioned. They want to do right by their client. They don't need the burden and hassle of regulations that sometimes is like, the square peg in the round hole just doesn't work for them. So the good news is we're moving back into that type of regulatory environment, and Atkins is just getting started. I think he's going to do great things, and I'm really excited about the fact that he's the chairman of the SEC.
I was always surprised with how much resistance there was against the fiduciary sort of standard, and it's like, to me, it's just common sense. But all right, I got some more questions for you here. You've mediated countless disputes. What's the funniest or most surprising thing you've seen people fight over?
Yeah. Well, I'll tell you, I'll give you an example from two different contexts, one like business, one non-business. So it may surprise people, but maybe it shouldn't. I started my career mediating cases in community mediation centers, which means, imagine somebody gets a visit from the police for like disturbing the peace or domestic dispute, and their options are you can go to court and potentially go to jail, or you go to mediation and try to work it out. And that's like kind of where we came in as the community mediators. So first time I went into this community mediation center, there is like an armed guard there, because like this is mediation. We're trying to facilitate discussions and make peace between people, but things could get really heated. Like you have two neighbors who have been at it with each other. And, there was one instance where things were just getting so loud between these two neighbors that like the guard had to come from out of the hall and come and sit in the room with us just to like remind them of where they were and what they were doing. And, the good news is at the process, I'm a really big believer in mediation. It worked. Like they walked out of there shaking hands with new understanding of one another, and they there were no further incidents. So it could be very, very powerful. But the surprise was in those types of situations, and I also find this, by the way, in the volunteer work I do, people just they're not on their best behavior. Let's just put it that way. In volunteer, when people are volunteering their time, I suppose they sometimes feel as though they're entitled to just kind of like say whatever they want to say because they're volunteering. And in like the community settings, it was kind of the same type of thing. It's like, this isn't a business relationship, so there could be some bad behavior initially. You don't see that in business settings as much. In those mediations, even if people are really upset with each other, there would be a degree of decorum and professionalism. And so that would be very helpful. And a lot of times in those types of settings, what I find is just the introduction of a mediator can be so helpful, because, each side really wants the mediator to be on their side and wants to make it seem as though they're, the other person, I don't want to call them their opponent because that's what we try to avoid in mediation, but that the other side is really the crazy one. And so like, they will have good behavior. They will engage in more constructive discussions. And I've seen situations where people come in and they're just so far apart. One mediation, for example, it was a disgruntled ex-employee who was suing their employer for like $10 million. Through the course of discussion, eventually they got to what the employer thought was a much more reasonable number, and they got to walk out of there having a very good relationship. And I don't think those types of outcomes are really possible in other forms of dispute resolution, particular litigation. So it could be very, very powerful.
So when things get tense in mediation negotiations, do you have like a secret move, like a go-to move to diffuse things?
Yes, there's a few things one can do. One is, mediator can always blame themselves, and frankly, there probably is some fault with mediators. We can make mistakes in those roles. There's different forms of mediation. There's a facilitative style where a mediator is really there just to kind of promote constructive discussion, and then there's also a form of mediation that's thought of as being more evaluative, which means the mediator actually has some subject matter expertise that they're expected to bring into the process. If things are getting really heated, or if, let's just say, the parties are stuck, the tool that a mediator has available to them, and this is something that could be instructive in business too, is just separate the parties for a little bit. Mediator can meet with each party individually. It's a technique called caucusing. Talk to them, find out what's going on, try to identify areas where there could be some traction that, in the presence of the other party, you just can't get into. That session remains confidential between the mediator and the other party. And then, because mediators, it's really important for them to always remain and appear neutral. You'll spend some time one-on-one with the other side, the other party as well, if nothing else, to promote and preserve the appearance of neutrality. And then, with the permission of the parties, you can then bring what you've learned in caucus back into the general session. And that can all of a sudden just kind of like be a complete game changer.
Sounds a lot like couples therapy.
I think so. Yeah.
What's the most underrated skill for success in finance that nobody teaches?
That's a really tough question. I think it's the ability, and I see this sometimes particularly from my colleagues who are like investment professionals. It's to recognize that maybe you've made a mistake or things aren't the way you think. I've seen investment professionals who have such conviction in a particular investment opportunity, and it becomes very hard for them to let it go. And the reason is they feel like it's supported by the financials and the models and all the like hard work they've done to get to that point of conviction. But at a certain time, you may have to allow for room that, maybe this isn't exactly the way you thought, and not get so attached and be able to like pull back, even if you have to do it slowly. And I don't think that's something that's taught in business schools or in finance. It's the emotional part of investing. And that can get people into a lot of trouble. But if they recognize it, and if they have like good controls or a team around them, like, for example, we would always require a review at my former firm if a stock fell a certain percentage, just automatically. It requires an objective review with other people who aren't necessarily sponsors of that name. That could be very, very important.
I've seen that in action. So
Yeah, I
I've
bet.
seen both sides of that. All right. How do you balance precision as a lawyer with innovation as a CEO?
Yeah, that's tough. And I ran into this a little bit when I was serving as both chief operating officer and general counsel simultaneously. Chief operating officer really wants to kind of push the business forward. General counsel kind of is in charge of the guardrails, make sure you're doing things properly. And I don't think they have to be mutually exclusive. And I think the best process is one where you are carefully thinking through all the legal and regulatory implications, and they don't necessarily become impediments, but they just inform how you can move a business forward in a proper fashion. And so, not only in my business, and when I was at my prior firm, I had a really wonderful relationship we had a CEO for a number of years, and then eventually we had two co-CEOs come in. My relationship was really excellent, and I think really aided to our ability to drive business forward. And when I look at my colleagues who are in those types of roles, general counsel roles or in advisory roles, the ones who are most successful are the ones in which the CEO really takes their opinion and advice into consideration, brings them to the table. And I think that's just part of being a good and thoughtful CEO, is listening to your advisors, whether they're your lawyers or your accountants. And look, you ultimately get to make the decision, like that's your prerogative, but listen to your advisors. I mean, they're there and they're really trying to help you. And then it's your job to kind of chart the best, course forward once you have all that information.
Good. Go back in time to the start of your career and think about the word success. What did that mean to you when you were getting started, and how has that changed over time? And what does success mean to you now?
When I started my career, it was with the government. So I was working for the SEC, and it was at a time when the SEC was not one of the more preeminent agencies, meaning salaries were very low for incoming attorneys when I started there. And so I wasn't going there in order to make a lot of money. I was going there to learn. And for me, what success meant at that time was acquiring skills or understanding that I could apply and utilize to help propel me forward in my career. And so the advice I always give my students in law school and, colleagues in the industry who may be a little bit earlier in their careers, and I think it even applies still today, is you should always have that like 3 to 5 year plan, and the decisions you're making should always be thinking about how are you setting yourself up for the near future and the longer term future. What are your goals? Where do you want to be? So as that young SEC attorney, I knew that one day I'd probably want to go and work at a more prestigious law firm or in a more prestigious investment management firm. So stepping into the SEC and putting in my time there, spending 4 years there. I honestly, when I started, I thought I would be there 1 year, but the work was just so rewarding and fulfilling. I ended up staying for 4 years. I wish I could have stayed longer. I then use that to kind of step into a law firm role at a very prestigious firm and working with some of the top financial services institutions in the industry, gained a lot of knowledge and understanding that I could then take into a role with my advisory firm. And, I was 32 years old when they offered me a position to become their general counsel. And, when I looked at it, I said, 32 GC, like that's phenomenal. I can always go back to a law firm. Like, how can I turn this down? It turned out to be the best decision I could make. And I think part of it was just always having kind of like that overall plan of like where I wanted to go and make good decisions as to how to get there. I definitely hit some bumps in the road along the way. That's going to happen for anybody. But there's the saying, like when one door closes, another one's going to open for you. There's some real truth to that, and you just have to kind of pick yourself up and find the best path forward if that happens, and just stay kind of like committed to the goals you've set for yourself, and think about how you're gonna get there, how you can achieve it.
Awesome. Great answer.
Oh,
Fun
thanks.
round of quick fire questions.
Okay, let's do it.
What book do you recommend most often?
Well, recently I've been saying Hamilton because it's so interesting to me. It's a very long, long book, probably more than 1,000 pages. And obviously everybody knows the Broadway musical, which is awesome. But the book itself, I have to tell you, it's so interesting because Alexander Hamilton led a most fascinating life. The coolest part of the book is looking at the political climate back then, when we were forming our country, and the similarities and almost like dysfunction that we see today, the extremes. It existed back then. I even actually keep a list of quotations from that book because they are so relevant to today, both politically and just from a sense of society. So, you can learn a lot from history, and that's one book I think has a lot to teach us.
Awesome. What's one thing that instantly earns your respect in a colleague or a client?
Authenticity and honesty. Sorry, two things, but they're kind of related.
Great answer. If your career was a Netflix show, what would it be called?
Oh, I don't know. It's probably not that interesting. I would say probably either I would come up with two titles. One's either the problem solver or the strategic advisor. Those are the things I really like to do.
Two good names.
Yeah,
What's
thanks.
something people would be most surprised to learn about you?
Maybe that I played rugby in college.
Really? Were you any
Yeah.
good?
It was a rugby club, small liberal arts university in Massachusetts. So it was fun. I had the experience of being tackled and sat on by a 310-pound, I forget what the positions are called, but really large, massive person sitting on me, after tackling me in a meet, something I'll never forget.
That makes you tough as nails for the rest of your life. So, right?
Maybe.
All right. And last question. The show's called Getting Real. What does that mean to you when it comes to compliance, regulation, running a business, and financial services?
Well, I think it's really holding yourself to a standard where you can sleep well at night, which means doing the right thing for your clients, showing up and delivering for them, performing to their expectations. And for me personally, and for my colleagues at FiSolve, we always feel as though it's really important to be uber responsive and be correct in the advice that we're giving. And so we always want our clients to feel as though they're being heard, that we're responding to them in a timely fashion, but most importantly, we're giving them accurate and helpful advice. And I think whatever area of financial services industry you may be sitting in, you will enjoy success if you can deliver those things.
Steve, this has been awesome. You seem like a really awesome guy, founder and
Thanks,
CEO
Dan.
of FiSolve. Thanks again for the expertise and perspective that you shared today. For everyone listening, there'll be links to connect with Steve in the show notes. If you've enjoyed the episode, please share it with someone in compliance, legal, or fund management who needs to hear it. And until next time, keep getting real. There's one thing I want
Thanks,
to
Dan.
add too, Steve. Are there any links or any way that people can get in touch with you if they so want to reach out?
Thank you so much for asking. You can reach us by email. It's info@FiSolve, which is like Fi solve SOLVE.com. And you can learn a lot about us on our website, which is FiSolve.com.
Awesome. Thanks so much, Steve. Really appreciate it.
My pleasure, Dan. Thank you. Thanks for having me.